This Guy's Garage. Like and subscribe.
Minister, something I'd like for you to address at this committee. Since 2015, violent crime in Canada is up 39%, homicides 43%, gang-related homicides 108%, aggravated assaults 24%, assault with a weapon 61%, sexual assaults, which goes at the root of the issue we have today, 71%. Sex crimes against children, 126%. Yet you're new as minister, but you're not new to the file, having served for some time as parliamentary secretary to the Minister of Justice. There's a quote that you gave that I'd like you to address, where you said, and these are StatsCan's numbers that I just listed. You said, and I quote you, "I think that empirically it's unlikely that Canada is becoming less safe." In the face of that nonpartisan StatsCan information and hearing what I'm sure you're hearing from your constituents, the same as all members of Parliament are, is that they feel Canada has become less safe. Do you still stand by your statement that Canada is not becoming less safe in the face of those statistics?
So thank you, Mr. Moore, for that question. Thank you for the work you've been doing on this committee for many years. What I'd say to you is that there is a distinct problem with safety and crime in Canada right now. And what I would say to you with respect to the statistics you just read is that I've been briefed on those statistics. And I've seen those statistics, including things like the Crime Severity Index. And I agree with you that we have a problem with crime in this country, particularly since the pandemic. And what I would say to you is that my fundamental job is to ensure Canadians feel safe in their homes, in their communities, at work, at play, in their schools. And what I would say to you is that that's one of the reasons why I've been very pleased in the first 2 weeks of Parliament to have two justice bills come up for debate, one dealing with bail reform, which all parties gave unanimous consent to, which will help keep Canadians safe, and secondly, restoring the sex offender registry, which will help people be kept safe, specifically from the sexual assault and sexual assault against children, which you highlighted in those statistics. So is there a problem? Yes. Will this bill help address this problem? Absolutely.
Thank you, Minister. Now, one thing I would take issue with, and I say this only because every witness that we've ever had at this committee dealing with safety, restoring justice to our justice system, all the studies we've had, I haven't heard any of them blame the pandemic, as you seem to have just do, for this stratospheric rise in crime in Canada. What I've heard them blame is policies that were deliberately instituted by your government, like Bill C-75, which created the catch and release or revolving door to our bail system that's putting offenders back on the street, like Bill C-5 that says that if someone commits a sexual assault, they can serve their sentence from their home rather than from a prison, as they should. So, Minister, would you acknowledge that the measures that have been taken by your government, like Bill C-5 and Bill C-75, that they also could have an impact on rising rates of crime in Canada?
Mr. Moore, this is where you and I will differ in terms of perceptions. I believe Bill C-5, and I was the Parliament Secretary at the time that was implemented. It was meant to do multiple things, including addressing delays in the court system, which were being pointed out by the Supreme Court in Jordan. It addressed things like reverse onus on bail for intimate partner violence. That is something that not only that we believe in as a government, but we have doubled down on in terms of expanding the scope of reverse onus provisions in the current bail reform bill, Bill C-48. What it also did is entrench certain principles about bail that codified Supreme Court jurisprudence. With respect to Bill C-5, Mr. Moore, again, I will categorically disagree with you. Bill C-5 was about easing the overrepresentation of Indigenous and Black persons in the Canadian justice system, in the criminal justice system, and the effect of some of the mandatory minimum penalties that were enacted by the previous government under Stephen Harper was to over-incarcerate Indigenous folks on a six-fold basis and in Black persons on a two-fold basis. And on a day on which we've elected for the first time in Canadian history a Black Speaker of the House of Commons, I'm going to stand by our efforts to reduce racism in our system and stand by the efforts to reduce overrepresentation.
Minister, thank you. The decision that we're addressing here, the Supreme Court stated that someone who's on the registry, an offender, is 8 times more likely than than the general population to commit a sexual offense. And that is why mandatory listing in the sex offender registry of those that are convicted of sexual offenses and mandatory lifetime listing of those who have multiple offenses is so essential. It was a 5-4 decision. In the dissent, I want to quote, it says, "It is also clear that it cannot be reliably predicted at the time of sentencing which offenders will reoffend. In the face of that uncertain risk, Parliament was entitled to cast a wide net." Have you given consideration to casting a wider net? Because what has been carved out in S12 are some fairly narrow provisions that would result in mandatory listing in the sex offender registry when previously any conviction for a sexual offense was listed.
6 minutes,
Have you
we're out of time,
considered
I'm afraid.
casting a wider net?
I'm going to ask Madame Dillon to start, and I'm going to leave it to her to decide if she'd like you to answer that question.
Thank you, Madam Chair. I'd like to congratulate you on your new role. It's my first time speaking in committee this session. And to our minister as well, thank you so much for coming. Welcome to committee. It's nice to see you here. If you briefly want to answer the previous question, or I can ask my own.
I'd be happy to briefly. Thank you, Ms. Dillon. First of all, the important takeaway from Bill S12 to Mr. Moore is that the vast majority of individuals will remain registered. That's the first point. And I say that because there's an automatic registration in 2 categories, and for everyone else, you're going to get registered unless you can demonstrate there's a rebuttable presumption why you shouldn't, because it would be overbroad or grossly disproportionate. So that's important. Have we given careful thought? Absolutely we have. But the most reflection that I gave to the bill was simply the fact that the Supreme Court said in its majority view that lacking any judicial discretion is a violation of the Charter under Section 7 because it's overbroad and doesn't meet the minimal impairment test under Section 1.
As a new minister, there's several things I'd like to talk to him about, like decriminalizing HIV non-disclosure, decriminalizing sex work, reform of extradition laws, and the bill that's before the House, C-40, miscarriages of justice.
Minister, you said at the outset sex offenses against children are despicable and you condemn them in the strongest terms. I think we all would at this point. You've also spoken about S12 and its role in the protection of children. I take it then you would support the elimination of house arrest as a sentencing option for those who are convicted for sexual offenses against children?
Thank you for the question. And what I would say, Mr. Caputo, is that it's really, really important that we have different tools that are available to ensure that judges have the ability to impose sentences that meet the crime, so to speak, that are proportionate to the crime. And I think what's important is that in instances, if I believe where you're going is this notion of a conditional sentence order are only available in very rare situations. So one would have to be sentenced to incarceration of less than 2 years. And most importantly, they only apply to offenders who do not pose a threat to public safety. In the context of a child sex offender, if a judge believes that that person poses a threat to public safety, the notion of house arrest is not on the table pursuant to legislation that's been passed by Canada.
Well, Minister, I want to go back to that because you talked about the denunciation and the denunciatory elements, and you're talking about public safety. There's an element of justice here as well. You're talking about public safety, and we can talk about CSOs a lot here in the next few minutes. But strictly from a justice perspective, the person who is the victim of sexual offense, the child is literally imprisoned psychologically for life. Are you saying that that child who's imprisoned for life psychologically, that the punishment for the person who offended against them should be that they serve house arrest for under 2 years? Is that your position?
That is not my position, and so I want to make sure that the record is clear. A person who has been convicted of a sexual offense against a child is actually subject to a mandatory minimum penalty, and therefore a conditional sentence order is not available to them. So the possibility of house arrest doesn't exist. I'm advised that by my officials.
I beg. Okay, so if I have your position correct, your position is that a person cannot get a conditional sentence for a sexual offense against a child. Do I have that right?
Child-specific sexual offenses are subject to a mandatory minimum penalty, which renders them ineligible for a conditional sentence order. That's my position.
Okay, and those haven't been struck down. So let's say Section 151 of the Criminal Code. And I'm thinking back to a case that I asked you about where a mother offended against a 7 or 8-year-old child. And the judge reasoned that it was the first time that it happened and imposed a conditional sentence order after trial, so no mitigating value. And it was overturned on appeal, okay? I believe that the charge was under Section 151. But I don't recall that the appeal was on the basis that the sentence was illegal. It was not proportionate. My understanding, and maybe the official can correct me, and I defer to Mr. Brock, but my understanding is that a number of those mandatory minimums have been struck down. So is your position that a person cannot get a conditional sentence order under, say, Section 151 of the Code or Section 271, sexual assault, if that is a sexual offense against a child? Is that your position?
So I'm going to defer to Mr. Taylor with respect to the two provisions you just cited, but the broad-scale proposition about child sexual offenders is that people who are convicted with respect to a sexual offense against a child are subject to a mandatory minimum penalty, and anyone who's subject to a mandatory minimum penalty is not eligible for a conditional sentence order, such as house arrest. I think the important aspect to respond to, Mr. Caputo, is that I share your concern about anyone who would commit a sexual offense against a child, which is why I want the sex offender registry restored, which is why we've been ensured to double down on the idea of a child offender being subject to an automatic registration and not subject to the judicial discretion.
I only have 30 seconds, Minister. If there is any wiggle room on this where somebody for a sexual offense against a child, including internet luring under 172.1, sexual interference or sexual offense, if there is any wiggle room for there to be a conditional sentence order, would you be prepared to plug that? Yes or no?
I think it's important to, and I think if you're making an oblique reference to your private members bill,
I'm not. I'm just asking generally.
Fair enough, Mr.
Yes, sir. We have 5 seconds. Yes or no?
So I would be open to looking at any aspects that will help keep children safe in this country.
So I want to start off by discussing the narrative of your government, sir, and some talking points that you yourself have used and your predecessor, David Lametti, has used to justify and selling, in my view, C-48 as an important piece of legislation to restore not only public confidence in the administration of justice, but to make our community safer. And I've heard repeatedly in the House that one of the hallmarks of C-48 is that you listened. You listened to stakeholders. You listened to premiers. You listened to chiefs of police and presidents of police associations informing the specific language to tighten up the reverse onus provisions in the criminal code and to add to the reverse onus provisions in the criminal code. But you'll agree with me, sir, that it wasn't just the ask of additional reverse onus provisions as it relates to additional firearm offenses that these stakeholders were asking. There was actually a laundry list of other items that they asked for that did not find itself into 48, and for lack of knowing what the agenda is from your department, I don't think there's any legislation that you're even bringing forward to contemplate encompassing the other asks. So, with that being said, the provincial governments, the associations of police asked for a reform of Canada's bail system, a thorough review of Canada's bail system. They asked for a definition of serious prolific offender or repeat violent offender within the confines of 48. They specifically asked for bail hearings for serious firearm offenses should be heard by a judge as opposed to a justice of the peace, a judge of a provincial court and a superior court, and to strengthen obligations with sureties as well as consequences for failing obligations. So my ask of you, with the limited amount of time that I have, sir, is why have this government, why have your department, you yourself, ignored those significant additional measures that the stakeholders are asking to, again, improve community safety and to restore confidence in our justice system?
So thank you, Mr. Brock, for the question. And I'd say, put to you simply that no one is being ignored in respect to the conversation about community safety by me or by my department. What I would underscore for you is that the conversation on bail reform starts within a letter that comes from the premiers to the Prime Minister after a FPT that occurred in October of 2022. That letter had a very specific ask, and we added to that ask in terms of developing the legislation. In terms of one firearms offense was listed there, we added an additional 3. You and I share the same province, the province of Ontario. Doug Downey's government, Doug Ford's government, and Doug Downey as the AG has been very complimentary in terms of what we've been doing and very supportive in terms of what we've been doing. What I found unique about the situation is that we had the support of all 13 leaders of every province and territory in this country, as well as all of the law enforcement community behind that bill. And that continued even as we saw it move its way through the Senate, and it's now in the Senate. And David Eby's government was continuing to lobby for its quick passage, even while it was being studied in the Senate. I think it's important in terms of the list you're mentioning to also underscore that when it comes to, and you'll know this as a former prosecutor, when it comes to setting in place the structure and the architecture, that's the criminal code, that's federal parliamentarians. When it comes to the administration of justice and things like bail enforcement, that's the responsibility of the provinces pursuant to the administration of justice under the constitutional division of powers. And what we've seen is we've put money in place, including $330 million for guns and gangs enforcement, that is helping provinces do exactly that. So there's some complementarity there, but in terms of my willingness to explore other options about keeping communities safe, as a guy who represents a riding in Toronto that has seen violence, particularly on the TTC, I'm committed to that. That is my fundamental duty, to keep Canadians safe. Bill C-48 goes in a direction that will do just that. It's an important piece of legislation that got all party support, which is a good thing. I think there's more areas of collaboration, and I'm willing to collaborate in those areas.
So thank you very much for that. I'm
Figured
now
that my
going to
time would
go
be up. Thanks.
to, yeah, you're out of time, Mr. Brock, for sure.
you.